that you have limited time. When you get yellow, you need to start wrapping it up. When you get red, you're done, unless we have questions, and we can keep you up here. So with that, let's go ahead and get started. And y'all have slightly more time on this one. So we'll begin with case number 22-10443, BS versus Waxahachie Independent School District, and we'll begin with Jordan McKnight.
Good morning, Your Honors.
We have two lawyers here. I wonder where the third lawyer is.
May I proceed?
Oh, I'm sorry, please.
This matter involves a then 8-year-old child who, as a result of a failure to put in place an appropriate individualized education plan, had a major behavioral regression during the 2016-2017 school year, which culminated in an event in which 911 was called. The 8-year-old child was taken down to a prone position and held there on the ground, handcuffed while he was screaming in agony, resulting in a subsequent stay at a behavioral hospital and further incidents where an ambulance had to be called for a teacher, and he was placed in an extremely restrictive one student to two staff setting with no other students at one point. Appellants are urging the court to consider the case law from sister circuits that a failure to address behavioral issues appropriately can result in a denial of FAPE, free appropriate public education for a student, and then to find that that's precisely what happened here. Appellants also urge the court to find that behavior plans are appropriate when they are systematic, contain detailed strategies, and inappropriate when those plans are conclusory, informal, and are not reasonably calculated to address a student's behavior needs. And
Well, you're paddling upstream against the findings, aren't you? I mean, the hearing officer credited the teacher's account that they did have appropriate measures in place, and we owe deference to that.
Well, we owe deference to that, but we also, you have de novo review of mixed questions of fact and law. And so we think that the behavior plan put in place, you certainly have the ability to review that de novo over whether that was appropriate. And the behavior plan that was put in place was not appropriate. Texas statute kind of gives a nudge to, requires schools to consider behavior strategies. Waxahachie's plan was 6 words long. It said, student has a social skills IEP. I asked the teacher, and it's in the record, is that the extent of your, y'all's discussion on strategies? And she said, yeah.
Yeah, but look at the record. I mean, every teacher that was with BS every day testified that they had a plan and had measures in place that would work, that were reasonable and working. And what evidence is opposed to that?
Well, I think whether they were working, I think you can look at the record and see that. Was that
what evidence opposes that?
What evidence opposes that the plan was in place and that it was reasonable and working? Well, I mean, the evidence that opposes that is how the things escalated out of control. I mean, they said he met his behavior goals, but look, at the end of the year, I mean, this student has had 911 called on him twice. They're constantly having to evacuate his classroom because of his behavior.
But there was a point at which his medications were changed. That was what caused the February problems, and when the medications were changed again, he got better. And that's something, obviously, the school doesn't have any control over.
Well, first let me say, they tried to create a dichotomy in the record between what's happening before and after that. If you really look at the record, and we detail this, in detail in our brief, it was just as bad in October and September and October as it was in February. I mean, there were constant instances of violence, trying to stab another student, multiple days where he tried to hit a teacher. What the record shows that the school district went into that IEP meeting.
Then in October, they did have some conference and made some plans. And so it wasn't until February again that there were problems, and that was when he was having some changes in his family, as I understood, in his family life.
Two comments on that. The only real change they made in October was to take him out of general education, or for academic courses, because they said it was based on academic frustration. And that really violates the least restrictive environment requirement that they...
No, it doesn't if he's having trouble with being in the general groups.
Let me explain why I believe that, or why we're asserting that, is because they didn't try anything to address the behavior. They didn't look at the function of the behavior. They kind of made an assumption, well, it's academic frustration. If we put him in easier classes, he'll quit having these behaviors. The opposite happened. They put him in easier classes, and then, as you know, they moved him down from working with 3rd and 4th graders to working with kindergarten, 1st and 2nd graders. The behaviors got worse. So their determination in October that this was about academic frustration proved to be wrong. That didn't actually fix the problem. And their own, their goals actually conflict
So
with
they
that.
not only have to do something, your contention is they got to do, whatever they do has to work, or the plan is a failure.
It has to be reasonably calculated, and it has to be based on data. And their data showed that it wasn't based on academic frustration. They said themselves it was attention seeking, but the record also shows it was sensory, and it was based on peer conflict. And so, they kind of made an assumption that they had no data for in the record, that it was based on academics.
Well, they had teachers who saw that he couldn't keep up in the 3rd grade class.
Well,
And, wait a minute, and he got frustrated and acted out. That's what the teachers saw and testified to.
well, and the record shows, though, when they had that October meeting, the teacher basically kept her mouth shut on how bad these behavior incidences were. She brought up one. The lower court found that there were 9 serious behavioral instances that semester. The record shows that the principal testified and the teacher testified. We only talked about the one incident in October instead of the 9. And so they did not have a reasoned conversation about how bad this behavior was. They made bad assumptions on bad and incomplete data. And that just doesn't meet the standard for, either, collaboration, coordination, individualization. It doesn't meet the Michael F. factors.
Where in the record does it say that? Who testified to that?
Well, I've got that in my brief. Principal Kazda was the one who testified that we only talked about the one behavioral issue, and she was only aware of the one behavioral issue from that art committee meeting.
Well, none of the teachers said that.
I believe Ms. Gooch testified that, and then Ms. Gooch testified in February. She also kept it to herself when the behaviors were escalating there too. Basically, Ms. Gooch, I don't know if she just didn't want the art committee to address this. She didn't want it to look bad on her, that she was letting things get out of control, but the record really shows she wasn't sharing with the committee how bad things were getting. And so
Now you're talking about credibility calls.
I don't think we're talking about credibility. It's just the record is very clear that that committee did not consider the full.
When you say that Ms. Gooch was not believable for one reason or another, you're talking about credibility.
Oh, I'm not challenging what Gooch said. I agree. I mean, Gooch testified on the record that, yeah, I didn't tell anybody in February how bad things are getting. We only talked about that one incident in October. I'm not challenging her credibility. That's what she testified. And so when that committee wasn't looking at the full record, was not looking at the 9 serious incidents that
So then if you're saying they didn't do anything right in the fall, how come there weren't any incidents in between the November-ish one and then February, when things did change in his family?
Sure. Well, as we point out in the reply brief, when the record was produced, the behavior choice sheets, which is where we found out all this behavior was happening, because it's not in their official records, those like 6 weeks were missing from November to the beginning of December. So once we start getting records again in January and February, well, look, we start having incidents again. So, I mean, that's a little difficult, but there's really.
So what did you do about that? You said the records were missing. What did you do about where are they and why don't we have them?
Well, I mean, I can't conjure records that aren't produced out of thin air, but that was back
Well,
5 years ago. So
you would not be the first lawyer saying, I need these records, Your Honor, please get them for me. I think I've heard that as a trial judge from more than one lawyer.
I think that regardless of what happened in November, December, what started happening again in January and February shows that ultimately the failure to.
I thought it was February.
Well, there was a violent incident in January as well. Obviously, things did start to significantly get worse in February. And our point is, if we had actually done the work in October, because the evidence was very clear in October that things were going bad by the time we held that meeting. If we did the work in October, we look at what are the antecedents of this behavior? What are the functions of the behavior? What kind of strategies can we look at?
What evidence do you have? I mean, and I don't want you to misunderstand this. I have deep respect for the issues of addressing disabilities, and I feel for BS and the family and all of that. But there is only so much. It's kind of like when you take someone to the hospital, they may or may not get better, and there's just sometimes that they can't. So looking at this, while I realize they have an obligation to do the best they can, what is it that they could do? I mean, this is a young one with a lot of issues, and that is difficult, okay?
To extend the medical analogy, if the doctor walked in the room and said, give him penicillin and, we'll see if that works, without ever examining him or trying to determine what are his symptoms, what does he look like, what's worked in the past, that would be a problem. And that's what essentially happened here. They threw something against the wall, said, let's see if this sticks.
Well, but even in that lawsuit where the doctor acted not very properly, you still would have to show that had the doctor done something different, it would have been different. So I guess I'm still wondering what here could have been done that would have prevented, because the school wants to prevent this too. They don't want to have to keep emptying classrooms, calling 911, having a teacher assaulted. So this is a situation, unlike some other disability situations, but this is one where the school also has a desire to succeed. So tell me what they could have done differently.
Sure, what they could have done differently is, and what we've pointed to that other courts have held that they need to do, is have a reasonably calculated behavior plan. What that would have looked like is, let's have a meeting, we could do a functional behavior analysis. The Texas statute suggests that for kids with autism who are having behavior problems, that they do a functional behavior analysis, that they put in place a behavior intervention plan. So then they look at the antecedents, they say, why is the behavior happening? What strategies can we use when that behavior is caused by this? What strategies can we use when it's caused by that? What has worked in the past? What hasn't worked in the past? Basically they create a comprehensive plan with detailed strategies. That's what the case law from other courts says that you have to do in order to provide a student with behavior issues of FAPE. You have to create a comprehensive plan that's reasonably calculated, that isn't conclusory. And all they have here is basically very conclusory solutions that they didn't think out.
And in effect, and the testimony was that he was improving, that he would come to them and say, we need to implement this plan. He didn't put it in those words, but he'd say, I need a timeout. I'm frustrated. I'm confused, and so he'd have a timeout, or I need to go outside. These were things they had in place, and they had taught him to ask for them.
Well, but they didn't ever formalize it as part of a plan. So when he moved from, say, one classroom to the other, like they did moving him from Gooch's classroom to Lockmy's classroom. The record shows she didn't really have access to even the IEP they had, but there were no strategies. She didn't know what the strategies were, and that's when things started to unravel. If this had all been if they had taken that data and said, this is what works, let's put it in part of a behavior plan that we've actually, thought out, that we've listed the strategies that work, that we list what causes those behaviors, and that can, move with him from one teacher to the other, then that actually could have worked. Then we could have prevented that. And that's what the case law suggests is really required here, that we take those things that work, we put them in a plan, and then we give that plan to teachers so that they can use to keep control of the classroom. When he moved from Gooch's room to Lockmy's room, she didn't know the strategies that worked that Gooch had used, and she didn't have a copy of the IEP.
Where is that in the record?
It would take me a second to pull up, but I can absolutely find that.
See, what I got out of the record when I read it was that these teachers talked all the time. They consulted with each other.
And I guess the issue there is that the law requires more than them doing that informally, kind of scattershot. It requires that they have a well-reasoned plan that they put in place, that they actually consider, that they base on data. And when you have behavior that's very much interfering with the student's academics, like this was here, we moved him from general education to special education because of the behavior, that we do more than just kind of take a half-measured approach, that we do more than just informal conversations, that we put it as part of a reasonably calculated, systematic plan with detailed strategies, not just some conclusory, guesses on what might work or what might not.
Is it irrelevant that the parents kept not showing up to meetings that they requested and did not sign some of the things that needed to be signed in the spring semester?
Well, as to the October IEP, I mean, first, obviously the record shows mom was 9 months pregnant. She wasn't able to attend the meeting. But the answer to that is no. I mean, other circuit courts have addressed this and been very clear that IDEA protects the child, not the parent. And so, I mean, we would expect, a school to have to follow IDEA, the same for an orphan who didn't have representation or for a, kid with deadbeat parents, as they would for any
If the parents
child.
wouldn't sign off on things that needed to be signed off on, how is that not a problem?
I don't think there was anything heading into the October IEP,
No,
which is
but
really
what
what's
about the
in
spring?
question here. In the spring, I mean, basically at that point, the case was already in litigation. It was filed March 9th. I wasn't on the case yet then, but I think that is what led to some of the difficulties between the school and, the parent coordinating at that point. But I mean, we really think, the crux of this case begins, at the beginning of 2016 up through March 3rd.
You
and
get a
that's what we
lawyer,
filed.
they should make things better, not worse.
Well, in an ideal world, that would be the case, but, parties under litigation sometimes have difficulty coordinating things like that. So, and again, we don't think that the school was handling that appropriate during that time period and wasn't offering everything that was
All right, if
needed.
we were to reverse, and I'm not talking about yet, we need to get to the police in just a minute, but
Yeah.
if we were to reverse on the school, what would happen next?
If we were to reverse on the school, obviously, basically we would make a finding that obviously the IDEA was violated. I think that would be remanded to the district court for basically remedy on that, and we're looking for, everything we've requested all along, that he get compensatory education. I believe the parent gets some reimbursement.
Well, he's in another school now, is he not?
I'm sorry?
Isn't he in another school now?
He is at another school, but I mean, I think compensatory education, that obviously the district court would consider that.
For money, basically, out in the lawsuit.
Well, we can't get money damages under IDEA.
What else could you possibly get?
I mean, basically in order, well, for one, reimbursement is something we've asked for and we've considered.
Reimbursement is money.
Well, I apologize. I'm making a distinction from money.
It's not damages.
Money damages
This is
are
what you're
not
talking
something we can get under IDEA. So I'm not, obviously,
Reimbursement.
I'm not asking for money damages, but that is something that's at issue here. And also, I mean, is it too little too late? Yes, but can there still be a compensatory award made? Yeah, absolutely. I mean, it's unfortunate that these,
How, when he's not there?
I mean, they can still make an offer of it, and or we can, we'll find a way to do it. I mean, that's
Okay.
Okay.
Well, you're running out of time, so I do want to get
Sure,
to the police.
let's address the case with the
I guess
city
the
and
question
officer.
I have on that is, again, I have deep respect for disabilities. I have had disabled people in my families, and so I totally, and I would respect it anyway, but I really do respect it. But the reality is, in addition to being very respectful of this child, the school also has to protect the other children. Even if you're not disabled, that doesn't mean that you should be attacked at the school. And so the police have to deal with all of those different pieces in a very short time. What is it that they're supposed to know? And how would things have happened if they had just let the child continue to run around attacking?
Well, at this point, the class.
We don't want to be in Uvalde.
By the time the police got here, the classroom was evacuated. Other children weren't really implicated in the issue. But I mean, we think, and I believe, there's really not disagreement. Phillips v. Prater is the case on point here, Fifth Circuit case. And there's really not a lot differentiating this case from Phillips v. Prater, other than, I mean, well,
Isn't that the taser?
a taser on a 10th grader and holding a 8-year-old child down with an officer's body weight while handcuffing him, it's not really that much different in extremity. But the difference is also that's what the officers did is not so much as important as whether it was open and obvious, the child's behavior. And here, the child's behavior was just as open and obvious as the behavior was in
Handcuffing
Phillips.
the child to protect the rest of the children, why is that a wrong?
Well, For one, I mean, you know, there's legislation in Texas trying to ban handcuffing for children under 10 and trying to ban putting children in the prone position. It's very dangerous. We'll obviously get to that when we get to the summary judgment stage. What's at issue here is whether it was intentional discrimination to do it.
What should the officer have done here to de-escalate the situation?
Well, you know, I admit I don't have the training on that. The officer doesn't have the training on that, but he should have, what the law requires of him is that once he realizes that somebody has a different disability, he needs to try a different strategy. And the real, what's at issue here is we're holding the student on the ground, and he's in handcuffs, and we keep asking him questions. We keep asking him, you know, trying to berate him, trying to admonish his behavior. He has autism and a speech impairment. He can't really answer those questions. He can't really do anything, and so he just screams and screams like the most horrific screams for minutes, and yet we keep doing the same thing to him. We keep going, what's wrong? You know, why aren't you calming down? And while the kid just, you know, screams and screams and screams in
They took
agony.
him to the principal's office and the mother came and got him. I mean, it wasn't like they had him there all day screaming.
Well, I mean, for one, we kept him in handcuffs long past the time that, you know, there was any necessity for
I
that.
watched the video, and it seemed to me the officer tried his best to talk to the kid.
And I think that's kind of the problem, is that once he'd ascertained that this is a kid who is diagnosed, and he asked that, you know, or is he diagnosed? Once he ascertained that there was a disability and that what he was doing was not working, they didn't change strategies for an extended amount of time.
Yeah, well, you can't tell me today what the officer should have done, and that's a key part of your. I mean, the officer had to assuming this was open and obvious, as I understand the law, the officer was entitled to know or be told what accommodation the person wanted.
Well, and I think, you know, we cited from the South Lake case, Judge Ho's opinion was that, you know, instead of handcuffing an autistic child, there is, you know, you have to look for a different solution than that. That's not a reasonable solution. You know, maybe basically the solution is, it's certainly not to handcuff an 8-year-old child and hold them on the ground while they scream. Let's try something else. That's not necessary to keep this child, an 8-year-old, when you're an adult police officer, you know, to keep the situation under control. There wasn't any other safety concern at that point. There's nothing there, and it looks like I'm out of time. But
Okay, you've saved time for rebuttal.
yes, I have.
All right, Ms. Walker?
Thank you. May it please the court, counsel. My name is Meredith Walker, and I'm here on behalf of Waxahachie Independent School District. The district court correctly affirmed the special education hearing officer's decision in the underlying due process hearing in favor of the school district by determining that the school district complied with the Individuals with Disabilities Education Act by developing an appropriate individualized education plan, or an IEP, and by providing the student with a free appropriate public education, or a FAPE. While I want to get to the Michael F. factors, because that's what the court looks to, I want to address some of counsel's points first. And I think where we start is at the Andrew F. standard, which says that we're supposed to evaluate a student's progress under the IDEA in light of the student's circumstances. You've already heard that the student had autism and the student had a speech impairment. But what I think it's important for the court to also understand is that the student had a full-scale IQ of 77, which put him in the 5th percentile of students. So this is a student who is very low functioning, and you can find those scores on the record on appeal at 1603. And so when you look at how this student was functioning in the school environment and look at how he progressed under his IEP, under Andrew F., it was absolutely appropriate in light of the student's circumstances. Now, with respect to the tribe choice sheets that counsel mentioned, I did want to note that all of those are in the record. You can find them at 1120 to 1122 and 2264. And those 3 or 4 pages actually detail his behavior from the beginning of the school year in August of 2016 through the end of December or into January. And so all of those sheets are there. And what you're going to see when you look at those is he went from meeting expectations 74% of the days to meeting expectations once the new IEP was in place to 84% of the days. And when you look at the fall semester as a whole, he actually met behavior expectations 80% of the time. And when I say that, what I mean is that there might have been a blip on the radar at one portion during the day where he might have had a misstep, but the tribe choice sheets actually show that he was able to pull himself back together and successfully complete the day. 80% over the semester is excellent behavior for a student in light of this student's circumstances. Now, when you talk about the student's behavior leading up to the October 2016 IEP, the behavior, which you can find on the tribe choice sheets, included spitting, not following directions, hitting, using unkind words, again, not following directions, using a loud voice. Those are not serious behavioral incidents. There was absolutely one serious behavioral incident that happened in October or leading up to the October 2016 IEP where he required a class evacuation. He arrived upset, he calmed quickly, and ultimately ended in a restraint that
So that's
day.
the just one that was discussed.
Yes.
Your point is, it's not a lot to discuss with somebody who has autism, that they're screaming sometimes or kind of attacking someone else verbally or something like that.
Absolutely. And then also when you look at, yes,
Actually, there's plenty of kids who attack verbally without being
there absolutely are. But also when you look at, so when Principal Kazda testified that she was aware of the one incident, well, of course she was only aware of the one incident. The principals only are aware of what comes to their office through a referral. The person that had the information on what was occurring day in and day out was Miss Gooch, his special education teacher. And she testified and provided information that showed that she took his behavior into account when she was developing his present levels of performance, which is what the goals were based on. And I know there's a lot of discussion about whether he did or did not require an FBA or a BIP, but the school district already knew what his functions of behavior were, or his antecedents. And that's the entire purpose of an FBA. Here it wasn't needed because, one, he wasn't having serious behavioral incidents, and that's shown throughout the fall of 2016. Again, a couple of blips on the radar, but overall doing really well. We knew that he had academic frustration. We knew that he wanted to gain attention from peers. We knew that he was losing in competition. That was an antecedent to his behavior. Being corrected was an antecedent to his behavior. And all of that was addressed either through positive behavioral supports, through his goals and objectives, or through the structured instruction classroom, or the SI classroom. And when you look in the record on appeal at 2810, it specifically talks about that the structured instruction classroom is for students who need individualized structured schedules and daily routines based on social educational needs. And so what was happening was he was able to get those behavioral supports because he was in a classroom that dealt specifically with
But
those
they
types of
said
behaviors.
that y'all were too conclusory. You needed to be more detailed. What's your response to that?
So I don't believe that's the case because when you look at his actual behavior goals, his behavior goals specifically dealt with curtailing that adaptive behavior that they were seeing leading up to the October 2016 IEP. So there were two adaptive behavior goals. One was to be able to walk in the hallway by keeping his hands and feet to himself. And the other was with prompting and talking with a staff member or a break or the use of a cool down place. So accommodations, behavioral supports, and the student will work towards not displaying negative behavior such as kicking, hitting, running, throwing objects, or refusing to work to seek peer attention. So the goals specifically dealt with the antecedent, which was gaining peer attention, and specifically dealt with the behaviors that Ms. Gooch was seeing in the classroom. And then again, when you couple that with the fact that he was in the structured instruction classroom, working with the teacher for his individual needs on his own schedule.
Okay, I'm not saying we're going to do this, but you heard towards the end of the oral argument with Mr. McKnight, we talked about, okay, if we reversed, what happens? Can you give me some insight on that? Because I did not feel like that was very clearly explained to us.
Absolutely. So as with any other case, you could reverse and remand, or you could reverse and render, and regardless of which.
No, I mean, I know in general what we can do. I
But-
think I'm well aware of that. I'm talking about this case.
This case-
What I'm saying is, what's the reality of it? Because in other cases where summary judgment is granted, we send it back for a jury trial, whatever, and I'm not talking about with the police, but with you all, what can you do because he's not in your school anymore? What reimbursement is there? What was done that year because he stayed in that school? Sometimes they take it to another school and they're trying to recover the amounts of that. I'm just trying to figure out this case.
Absolutely. So what's going to happen is if you send it back down, then there's going to be briefing based on what the court does, reverse render, reverse remand, whatever the case may be. There's going to be additional briefing depending on what you did. And then at that point, the parties would brief who was the prevailing party, because under the IDEA, prevailing party status is how you get to compensatory education, and prevailing party status is how you get to attorney's fees. So then there's briefing on who's the prevailing party. It's a much different
So this is just about attorney's fees? I mean, what reimbursement besides attorney's fees is there out there?
So there would be compensatory education, but even then, the district court would have to determine what would be appropriate compensatory education.
I'm just struggling on that because he's not there.
Correct. So the
Okay,
parents.
and then on reimbursement besides attorney's fees, which I realize are large, what did they spend money on that year?
So if they received any outside services that they claimed that the school district.
But did they?
I don't believe so.
Okay,
So it would really truly just be.
the attorney's fees?
And compensatory education, but even that is, the court's gonna look at things such as, to the point you were making earlier about the problems getting the new IEP, the school district was continually trying to get information and get the parents to sign and get the parents to sign off on an FBA and a BIP and a new IEP, and so those arguments are gonna come into place.
And the attorney's fees don't benefit the kid, they benefit the parents, so the parent's conduct is relevant on that, right?
Well, and it absolutely is relevant.
Because they went and got a lawyer and then just stopped complying with things he needed to comply with. That doesn't strike me as a good basis for attorney's fees.
Correct. When the school district was trying to schedule meetings in the spring of 2017, the advocate was canceling meetings, not allowing the school district to go forward. It's all set out in our factual background, but that's all of the issues that were happening. And then when you look to see when we finally implemented the new IEP in May of 2017, his behavior got better. There were no issues, but we still even had to wait an additional 5 days to get that implemented because the parents would not waive the 5 days. They wouldn't sign off on getting the FBA and the BIP. And so the school district absolutely believes that's relevant. But when you look at,
What additional measures were put in place in February that was not in place before?
absolutely, let me get there and I will tell you what we did. So once the behavior started escalating in February of 2016, the school district talked to the parents about putting in a behavior intervention plan and getting a functional behavioral assessment done to see what was happening. Then they also did a behavioral specialist referral for the behavior specialist to come in. They called an ARD committee meeting to try to put some additional supports in place. And so they were doing everything that they could do short of getting
What I want to know is, in plain English, what additional supports were put in?
So the behavioral specialist came in and made recommendations to Ms. Gooch and Ms. Walke, and at that point they were working with the behavior specialists McGuire and Edmondson, who were giving them things like talking to them about what positive supports they could put in. I'm not sure what those exactly were. I don't think it's necessarily in the record, but it would be things such as the if-then principle. If you do this, then this will happen. So those types of positive behavioral supports to help the situation.
But some of the things they wanted to do, they couldn't because they weren't signed off of by the parents.
Correct. But even with
And where does that fact play into the question of kind of should we reverse, should we remand, should we render, should we do X, Y, Z?
So that goes to the third Michael F. factor, and the third Michael F. factor is coordination and collaboration among key stakeholders in the implementation of the IEP. And so from the school district's perspective, we were working with the parents, we were trying to call meetings, we were keeping them updated, providing them information. And then when the student's circumstances changed, not only did he have a change in medication, his family moved at that time and a new student was introduced in his class. That's a lot of change for a student with autism. And the behaviors escalated, and we were trying, or the school district.
Well, and
was
his
trying
mother
to
had a
address it.
baby, right? And did that make a difference, or did she not? Because she was pregnant, so did she not have a baby?
I don't know if she was pregnant. I just knew that
I thought they said in October she was 9 months pregnant.
that might have
And
been
generally, 9 months is when you give birth.
birth. Yes.
Maybe I'm mistaken, but that's my understanding.
I will be honest.
So then, if you give birth in October, typically that's a little baby in February.
Yes. plus the moving, plus the medication, plus the new student.
Okay.
So again, a lot of change for a student.
But you don't know if there was a baby?
I don't know.
Okay.
I haven't paid attention to whether she was pregnant. I'll be honest, because that hasn't been my focus.
Well, that was her statement of why she didn't attend that meeting in October.
Yeah. So when you look at all of that, but even when you're looking at the student's progress, so back to the third Michael F. factor, it absolutely plays into it and shows that the school district was coordinating and collaborating with the parents to make sure that they were implementing the IEP. But then I also want to look at the progress the student was making, because you cannot make progress under an IEP if it's not individualized on the basis of your assessment and performance. And here he was earning passing grades on his report cards. He was making progress on his goals and objectives. He learned 15 new sight words, improved in spelling, increased his DRA reading score, demonstrated mastery of generating rhyming words, demonstrated mastery of his science, social studies, and math objections. He mastered his walking in the hallway without touching walls. He improved his ability to show positive strategies when frustrated. And all of that's at the record on appeal between 1677 and 1691, and then 1931 to 1947. And so he made great progress in light of his circumstances. And that's the most important Michael F. factor that the court looks to in determining whether a student's IEP is appropriate and in determining whether a student was provided with a free and appropriate public education. Going back to the issue of whether we should have, or the school district should have done an FBA and a BIP, most of the case law that opposing counsel is relying on comes from the Eighth Circuit, and several of those cases are Pennsylvania cases. In Pennsylvania, the state law actually requires FBA and BIPs for certain students. That's not what the case law or the statutory authority in Texas says. In fact, when the Texas legislature changed and added the FBA and BIP requirements during the last legislative session, and it's in Chapter 37 of the Texas Education Code. It specifically did so to implement BIPs and FBAs with respect to a student's behavior when they're being removed from their placement, so when there's a manifestation determination review. So that's what the Texas legislature started looking towards. So if they had wanted to have a more stringent requirement where FBAs and BIPs were always required, they had the opportunity to do so, and they did not do that here. So I think that's an important point. And so that brings the court back to the Michael F. factors, which is what this court looks to make sure that a student's IEP is appropriate and that it's providing a student with a FAPE.
Let me ask you this: if the student's IDEA doesn't provide for moving him back to a lower grade level, can the teachers have discretion to do that?
So here the school district was not moving him from one placement to another. The placement that he was in was the structured instruction classroom, and there were two of those. There was one for higher grades, there was one for lower grades. And he was doing better in the lower grades with the younger students. But because it was a structured instruction classroom, he was working on his same goals, his same schedule. He was just doing it in an environment where he felt more comfortable with younger students, but nothing about his IEP changed. So that's different than moving him to a completely different placement, say a new behavior classroom, or making him completely mainstreamed or taking him one-on-one. He was in the same placement, he just was in a different classroom within that placement.
Now, what courses did he take with his peers, with his grade?
So with his peers, he did, I believe, let me see, he had art, music, computer, and PE with paraprofessional support in the general education setting.
So none of his academic courses.
And all of his academic courses were in the structured instruction classroom. And again, remember, we've got a student who's in the 5th percentile on his IQ. So.
And he stayed with Ms. Lockamy for all of those classes.
So he was with Ms. Gooch and Ms. Lockamy. He was moving to Ms. Lockamy for math because he was doing better. And then after the incident happened, he went to Ms. Lockamy full time. So with that, and for the reasons argued today and the reasons in the school district's brief, we would ask that the court affirm the district court's decision, finding the school district complied with the IDEA, developed an appropriate IEP, and provided the student with a FAPE. Thank you.
Okay, thank you. And now we'll hear from, is your name GM Nova or just Nova?
It's Darrell Noga, Your Honor.
Okay. I don't know why I have this.
With a hyphenated French middle name long ago.
Oh, I see. Okay, I get it. All right, Mr. Nova, we'll hear from you.
Well, thank you, Your Honor. Darrell Noga on behalf of the city of Waxahachie. Open, obvious, and apparent. Open, obvious, and apparent. And after having this case for some 3 years or more, plaintiff's attorney still can't tell Judge Davis what was open, obvious, and apparent as to the accommodation the police officers should have seen in seconds or minutes that they were on the scene. And we're not talking about a Fourth Amendment case. Keep in mind that Judge Lindsay and Judge Ada Brown both granted the officers qualified immunity, disposed of the Fourth Amendment claims. They weren't appealed, and the handcuffs are not at issue. The judges ruled that was perfectly reasonable. The officer's conduct was found to be reasonable. I believe that was a line in Judge Lindsay's opinion dismissing the claims initially, and Judge Brown echoed that. You have to have 3 words, open, obvious, and apparent, that apply to 3 elements: the nature of the disability, the limitations resulting from the disability, and the necessary reasonable accommodation. Now, plaintiff never addressed the limitations resulting from the disability in his pleadings, and he never addressed the necessary reasonable accommodation, which is exactly why Judge Ada Brown said plaintiff has not made any allegations that would show the limitations that resulted from plaintiff's disability, and that the necessary reasonable accommodation were open, obvious, and apparent to the officers. He didn't do it.
Well, and I just want to be clear that I'm correct that the reasonable accommodation still has to be protective of the other people. In other words, you can't just say, well, let this kid just run around and punch everyone and kill everyone. That's fine, because then that's a reasonable accommodation. That would be an unreasonable accommodation,
Absolutely,
right?
Your Honor.
So the police are in this mix of wanting to be respectful of this young kid, wanting to take care of this kid, but also wanting to protect everybody else that's in the building.
Absolutely, Your Honor.
Is that a fair statement? And there's nothing in the law that says otherwise, is there?
There is nothing in the law that
I
says
just wanted to be
otherwise.
sure on that, because
are,
that
Your
seemed
And
not addressed very much, like the reality of officers in an emergency having to deal with a lot on
That's
the plate.
precisely so, Your Honor. And you'll notice when you look at the video, in the video, by the way, the record was a little bit misstated by counsel, because it was interesting. The officers got some responses from the child that were very coherent. They weren't cooperative, but you'll hear...
I don't want to tell you my mother's name.
Yeah.
Yeah.
What's your mother's name? None of your business. Are you going to talk to me? No. Why are you so angry? Shut up. Hey, if you don't calm down, we're going to have to use handcuffs. I don't care. Those are not cooperative, but they're coherent responses. And what the officers observed would be consistent with an 8-year-old throwing a crazy tantrum. But you'll notice from the video, the first thing...
Which regular 8-year-olds that are not disabled do sometimes,
Yes,
right?
they do.
Okay.
Unfortunately, this is true. So when the officer walks in the door, a chair, the first thing he sees, Officer Young comes in and a chair hurtles at his face. He grabs it with one hand. Thankfully, it's headed right at his face and head. It was a pretty good toss by this young man. So the threat, he's holding the child and he's talking to him. He's trying to de-escalate.
Okay, can you explain the hold, because I just want to be sure. They said, he put all his weight on the kid, and I didn't understand that to be the case.
I think that's a Scott v. Harris. Look at the video. As Justice Scalia said, if the video contradicts what plaintiff says, you go with the video. The video shows that he's holding the child's hands. They're kind of tilted on the side. He's not laying prone on him for a number of minutes. The child is struggling. He's trying to talk to him. He's trying to de-escalate the situation. Ultimately, when Officer Lewis comes in, Officer Lewis is trying to talk to him. These officers behave in exemplary fashion. They're getting responses from the child. I'm not telling you my mother's name. Shut up. No, I won't talk to you. And they're saying, hey, buddy, we don't want to have to put handcuffs on you. And they're specific. They say, we're not arresting you. We're just doing this so you don't hurt yourself or anybody else. Now, I would say that what they did was exactly what they should do, because they took those handcuffs off. At the end of the day, if you will look at the video to the end, at the end you see a now somewhat a calmed down Braden who has the handcuffs off. At the end of the video, he hugs the principal and shakes Officer Lewis's hand. Now you're going to tell me that that's comparable to Prater? Prater, where, by the way, you did dismiss the claims on a 12C motion on the sheriff because of factual insufficiency. But Prater, you have observation for 5 minutes or more of a high school student, which is not an 8-year-old throwing a tantrum, a high school student putting his fingers in his ears, standing motionless, being uncommunicative. And instead of de-escalating, you use a taser? You leave him lying in a pool of his own urine for 13 minutes, as opposed to shaking hands with the officers, a calm young man hugging his principal? That's the same thing? It's exactly the same thing? It is not. This is not a case like Delano Pyle. This is not a case like Perez where you have deafness. This is not a case like Cadena where you have somebody in a wheelchair where you say, I see they can't walk. I see they can't hear me. This is a case where the only thing you have, and Judge Brown said that, she said, look, even if I conceded that there was an open and obvious nature of the disability, and I would suggest that when the officer says to him in the middle of
Wrap up your time.
in the middle of holding him, he says, is he diagnosed? He didn't know. But there is surely no open, obvious, and apparent facts. The pleading rules aren't suspended for the ADA.
Nothing open and obvious about what they should have done is what
Correct.
you're saying.
And
Could
there
have
are
done
no-
differently is what you're
Correct.
saying.
And there's nothing open and obvious about the limitations. And I will close by saying that this case should have ended where the video ends, with a hug and a handshake. Thank you for your time.
All right, thank you. And Mr. McKnight, you save time for rebuttal.
First, I'll confirm there was a baby, and you're right about 9 months.
Okay. I just thought it was sort of strange that there was,
Yeah.
that she was pregnant and 9 months pregnant, and then there's no, and certainly, of course, babies can be lost, but there was no discussion of that either.
What Ms. Walker told you about what they did in February, that we did it, we tried to do an FBA, we wanted to do a BIP, we talked to a behavior specialist about behavior strategies, and we put those in place, and we looked at if-then statements. We had the notice to do all that in October. That's what other circuits have required of schools, to do that in October. If we'd done that in October, we probably could have averted the de-escalation that happened in February and March and on. Ultimately after letting things get so out of hand, letting this kid spiral, then they start doing the right things. If we had done that in October, which there was notice to do in October because of the behavior, and which the statute tells them to consider, and which IDEA requires of them, if they had done all that, we wouldn't have ended up with these terrible situations. Now, as far as relief, I wanted to talk to you a little bit more about that. We pled for individual educational evaluations. They can still fund those. We pled for compensatory services, including like ABA therapy and counseling. We're still asking that.
Your prayer
court to
just
order
says
those.
reverse and render. That's kind of an unhelpful prayer.
Well, and I mean, we'll ask the district court to do that, but yes, I mean, we're asking for private counseling, for private tutoring, that all that can be paid for by a district court. So yes, there certainly is relief that can be done here besides just attorney's fees, in the form of private services. Let's see.
But that's
Now-
really a remand because the district court would have to assess that.
I'm sorry?
That's really a remand that the district court would have to assess.
Right, understand. Now, when we talked about what they knew at the October meeting, you know, they're required under the law, and this is addressed at page 5 of our reply brief, to have a PLAF, to have a present levels where they talk about what is this kid's level of behavior. And it's completely deficient. So the fact that the teacher only came in there and talked about the one incident is critical, because, you know, that's a requirement of any IEP, that we talk about what the kids' present levels are. And what was stated at that meeting has no correspondence to reality. And if it had, then we could have started doing some of these strategies that they do later. Let's do an FBA, let's do a BIP, let's consult a behavior strategist and do that. Now, and this is important, they didn't, the reason the testimony shows they did not bring a behavior strategist to that meeting was because Kaz that testified, I was only aware of that one incident. But, you know, the record shows there were 9 serious, and that was the lower court's words, 9 serious incidents in that fall semester.
Ms. Gooch was in the meeting, though.
I'm sorry?
Ms. Gooch was in the meeting.
She was in the meeting, but she was responsible for developing that PLAF, which should have been provided to everybody in advance, and it's deficient. And we addressed that in our reply brief, how it's deficient. And if that had been done appropriately, then the committee would have had to take additional and more considerations.
Well, but she knew everything on the ground. She knew what was in place and how he reacted.
She was on the ground, and she was responsible to report that to the committee, and she failed to do that. And
Now,
so,
how do we know she didn't tell the committee?
I mean, she testified to that, and that's in the record, and we point to that in our briefing. And it's in the record also that Kaz testified, well, we only discussed the one incident at the meeting. So it's multiple members of the committee, there's evidence that they only addressed that one issue. Now, I did want to address real quickly on the open and obvious. I mean, you know, we believe it would have been open and obvious if once he's assessed that he's disabled, what supports work for this kid? What do you do to calm him down? Do you have a behavior strategist that deals with autism? Because they did. Do you have a LSSP here, a licensed specialist in school psychology? Because they do, who works with this child? What do they say? You know, what can we do instead of holding this kid on the ground while he screams? You know, basically, I mean, let's get more information. How do you de-escalate him? And further to address, you know, I understand the safety concern, but at that point, there wasn't really a safety concern to anybody else in the room. The kids had already been evacuated for several minutes. He wasn't trying to elope from the room. There's nothing in the record about that.
Well, you had the staff in there, though, and, you know, he's throwing stuff.
You know, there's really nothing in the record from the staff at that point saying that, you know, hey, we felt we were in further danger. They could have left the room. Let's see. Now, I want to address real quickly also, you know, they talk about...
You're out of time, so I'll let you wrap up with a sentence.
Sure. They talk about positive academic and non-academic benefit, and they say, well, look at, you know, 80% of the behavior times, you know, he mastered not touching the walls. If you really look at the record, I mean, the behavior goals were not met. I mean, even if they're ticking the boxes that, yes, we met the behavior goals, this kid's behavior spiraled out of control. I mean, if just ticking boxes saying he's doing okay is enough.
I think you've already mentioned that. Thank you very much. So thank you, everyone. Your case is now under submission. We're going to take a 5-minute break.